Call the next case, please.
Morning, Your Honors.
Good morning. Give him a second to get
Sure.
settled.
Absolutely.
We'll hear from the appellant. Yes.
Ready?
Yes, sir.
Morning, Your Honors. Daniel Turkley of the Wilson County Bar. I represent Mary Jazzabi, the executrix of the Ben Jazzabi estate. With your approval, I'd like to reserve 5 minutes for rebuttal.
That'll be fine.
Your Honors, if I'm able to communicate one thing during our brief time together this morning, it is going to be that the plaintiff appellee is guilty of the first uncured material breach and most likely the only uncured material breach in this case. And that is going to be the failure to pay the simple rent payments due under this lease purchase agreement between the parties. For the most part, this case is going to involve matters of law and a de novo review. We're going to argue, Your Honors, that even under the favorable ruling that the plaintiffs or the appellees got in this case, even under the findings of fact that Judge McClendon made, the plaintiff appellee is still objectively in breach of the contract, even based upon the schedule of payments that the court found in her favor. This case involves a lease purchase agreement between the parties signed on May the 31st of 2011. At no point after May 31st, 2011 was Ms. Kenia Moreno, the plaintiff appellee, in compliance with the rent portion of this agreement.
But did the lessee have to be in compliance in order to exercise the purchase option?
And that's a good question, Your Honor, and that's the argument that is being made by the appellee, that essentially the special stipulation portion of this contract did not explicitly state that the
Normally, that's the way we do it in contracts. We say, provided the lessee is not in default in the terms of the lease, they may exercise within the term an option to acquire the property. But that language is not in this lease.
Understood, Your Honor. I guess the argument we would make, though, is that this agreement needs to be evaluated based off of the June 2013 repudiation of this contract by Mr. Jazzabi. As of that date, when Mr. Jazzabi terminated this contract, repudiated this contract no longer existed. There was no option left for Ms. Moreno to exercise. There may very well be a colorable argument that had this agreement still been in place, that perhaps that argument from the negative, would have merit. But in this case, there was a unambiguous repudiation of this contract in June of 2013 by Mr. Jazzabi based off of the breach for failure to pay the rent by Ms. Moreno. The terms of this contract, Your Honor, it lasts for 3 years. There's to be a $10,000 initial down payment and $500 a month in rent. And again, at no point after that May 31st, 2011 date was Ms. Moreno in compliance with that provision. Mr. Jazzabi, for his part, was patient with the Morenos. He sent multiple letters on the first one, October the 12th of 2011, indicating that the down payment itself had not been complete, the $10,000 down payment, and that no rent had been received to date. And in fact, the assertion by Mr. Jazzabi that no rent had been received to date is echoed in the order. The first payment found by the court to be made in this case was in November 25th of 2011 for $1,000, 6 months after this agreement was initiated. A second letter was sent by Mr. Jazzabi on May the 14th of 2012 saying that he'd only received 2 months of rent at that point and that Ms. Moreno was woefully behind on the rent. And it wasn't until just a little over a year after that, on June 20th, 2013, that Mr. Jazzabi wrote another letter to Ms. Moreno saying that she is behind on the rent, she has been perpetually behind on the rent, and that he is terminating the contract, unambiguously repudiating it. So
had there been any efforts by the June 30, 2013 for the lessee here to exercise the purchase option?
No, Your Honor.
When did that first occur?
That happened 11 months after this repudiation in May of 2014, when Mr. Alexander, counsel for Ms. Moreno, sent a letter to Mr. Jazzabi demanding that he show up to close, and that closing never did occur. I don't recall if Mr. Jazzabi explicitly refused or just ignored it, but that in any event, it did not occur. That is the breach alleged and implicitly found by the trial court that Mr. Jazzabi did not close on this deal, and that is the only potential breach that Mr. Jazzabi would have. And in any event, I don't think we can lose sight of the fact that the first uncured material breach has to be by Ms. Moreno, and she wouldn't necessarily have standing or the ability to exercise that clause, even if this had not been repudiated. Now, again, I would concede that it might be a more colorable argument had it not been repudiated, but I think the status of the first uncured material breach is significant in this case. There is a kind of a side issue which may have contributed to the court's ruling in this matter. It involves the detainer warrant that was filed by Mr. Jazzabi against Ms. Moreno in June of 2014. The implication that apparently is that because Mr. Jazzabi left blank the box indicating how much the arrearages were from Ms. Moreno, that was somehow an affirmative representation to the court that no money was actually owed. In reality, the warrant itself, which is an exhibit in the record, is just a blank box. It just states he wants possession of the property. And there's the statute is cited in the brief that essentially states that even in that case, the court has a obligation to determine what those arrearages are in the first place. Given the notice pleading regime that we have, and the fact that that box did not say zero, it was just simply left blank, I don't think there's any good faith argument that was a representation that no monies were owed. And in fact, as Your Honor indicated, Ms. Moreno is not even attempting to argue that she was in compliance with that lease. It is simply an argument at this point that perhaps she had the right to exercise that option with or without being in compliance with that, provision. So we would ask the court to take a look at that repudiation in June of 2013 by Mr. Jazzabi, rule that validly voided the contract between the parties. At that point, at a minimum, at that point, there was no further, option remaining in this case. To find that the assignment of significance by the court of the detainer warrant showing showing a blank box for the arrearages owed really was not significant at all, and probably contributed to an erroneous ruling. And then going back to the first part, essentially that the repudiation was valid in and of itself. And at this point, I'll take questions or yield my time. Thank you, Your Honors.
I hear none. You have your time for rebuttal.
Thank you.
Hear from the appellee.
I don't agree in this record in the first place that my client breached the contract first if there was a breach. That contract says that they're to provide insurance and taxes, and he never would give it to them. And if there were two lots that never were divided, he was supposed to divide them, and they never were divided. Mr. Lux, who was the brother-in-law of my client, kept working on the property, and as the court noted in its order in page 91 of the record, he kept taking the money. And as Ms. Moreno, the sister of my client, says in her testimony starting about page 21 through 24, she says, look, he would come around, want money, said, I'll bring you back a receipt, and never bring back a receipt. So when I filed the complaint, I filed with what they had paid, or believed they had paid. They didn't have a receipt, and they got really punished for that in this case, because They believed that they had paid, I think, $28,000. It's attached to the complaint, and the court didn't give them credit for that full amount because they didn't have receipts. And the testimony of both sisters is he'd come around, he'd get money, I'll bring you back a receipt, and never do. They were set up to fix this property up and then get kicked out. That was the deal.
So when did your client exercise the purchase option here?
Well, it isn't really clear, but the record reflects that in April of 2014, they tried to exercise it, and Mr. Jazzabi said, oh, the contract's no good, but I will sell it to your sister for $20,000 additional dollars. And while this contract was going on, he entered into a contract with my client's sister to buy it, and when she got the money, and it's in her testimony, he says, oh no, I can't sell it to you either, after she had paid it.
So what about the lessor's letter here terminating the lease?
What he says in those letters is conditional.
So you're saying those weren't effective terminations?
They were not. He says, I might let you stay if you'll just continue to pay. And then he says, I'll let you stay until the end of May. And of course, my letter was dated May the 14th. So they wasn't final. And all that time, the sisters are trying to get him to come to closing on the option. Now, I would also point out, and the court pointed this out on in the opinion, and it's on page 11, cited in my brief. They're arguing breach of the lease. This option is so generous. I've never seen one like it. Usually it says if you don't comply with the option, with the lease, you don't get to do the option. It doesn't say that. In fact, the option says, notwithstanding anything in the lease. Basically, it says this supersedes all of that.
Now, I would agree with that, but isn't the question of whether or not the lease was effectively terminated critical here? Because if you look at a combination of the introductory paragraph plus Section 15, which is the default provision, plus Section 26, you come up with an interpretation that in effect says 26 trumps everything. There's no requirement that you're in compliance with lease. But Section 15 default says landlord or lessor may terminate the lease, and the lease is defined as both the lease hold but also the agreement itself. So effectively, the lessor could do away with the purchase option by an effective termination. Wouldn't you agree with that?
Well, that could be what I might think of as an extreme interpretation. What you would have to do.
Tell me why that's an extreme, because that's the way I'm reading this lease, and I want to understand why that's extreme.
I'm sorry, Your Honor. Number one, the option obviously trumps everything above it. So you'd have to say that's not correct, that it really don't trump everything above it, notwithstanding any provisions in the lease is what it says.
So your position would be the option lives on even if the agreement itself is terminated.
I've cited a case, and the court cited several. I've cited a case from this court that says that it is a separate contract. And that case was, ironically, May the 14th of 21, I think. Judge Bennett authored it. That says, and the court agreed, it's a separate contract, but this option is so generous, it talks about at the end of the 3-year term, if they can't get financing. What happens if they can't get financing? So it clearly was anticipated that they would have 3 years to exercise that option. Now,
Let me, before you leave that, so it's your client's position that it doesn't really matter if she was in breach of the lease or not.
I think that I think that's true, and I think that Mr. Jazzabi's actions, as noted by the court in the opinion, belies his words. His words in the letters are conditional. If you want to stay, I might let you stay, and they're all conditional. And he kept taking money. So the best argument they have was that they were tenants at will with an option to purchase that was good for 3 years. And they tried to exercise that option. He wouldn't even respond. And let me say something about the detainer warrant. Not only did we have trouble figuring out how much was paid, my client never agreed that they didn't pay everything. They just said they didn't have receipts for it. Not only that, but when he goes to the General Sessions Court, he gives the General Sessions Court a detainer warrant with nothing in there for back rent. Now, this is not the Mr. Jazzabi that we read about and read of and hear his testimony in the transcript. And let me point out one more thing before I sit down and or answer any questions and sit down, or try to answer any questions and sit down. He breached this lease continuously. The record is replete with him coming over there and just dominating the place. Hold out your hand and spitting gum in my client's sister's hand, knocking down their garage door, letting air, police reports are letting air out of the tires.
That's all is abhorrent behavior, but I don't necessarily agree that that breaches a lease.
Quiet enjoyment is what I'm referring to, Your Honor.
Okay.
I think they were entitled to quiet enjoyment, and they never got it. Finally, they said, well, we'll just exercise the option, and we won't have this problem anymore. Now, they got burnt because they didn't keep receipts, but we're not conceding that they didn't make all the payments. We just can't produce a receipt for it. And the record's replete with that, and I think he made the first breach by not giving them quiet enjoyment from the very beginning. His plan was, and I think a reading of the witness's testimony and this entire record, and after all, the court heard from everybody, and is the best determination of whose credibility she believed. He planned to let Lux fix that place up. After all, early in Moreno's testimony and early in Lux's testimony and early in Kenia's testimony, had no walls, had no roof, had no floor. It was leaking. They were fixing it up, and that points to one more problem, Your Honor. This all points to why you should have a lawyer if you're going to purchase a piece of property and have somebody do the contract right. But there is something to be said, and the court took this into account. There was an agreement with Lux, the brother-in-law, to move in there and work on the place. And then there was an agreement with my client to lease and purchase at Lux's request. The money that was paid over this period of time, it is almost impossible to determine what part of that went to before the lease and what part of it went to after the lease or should be credited. I think the court on page 5 deals with that issue. of her opinion, and gives a pretty good accounting. She says we're just going to accept their payments as of this date. There was a lot more money paid. As a matter of fact, the testimony of Moreno is that when she got ready to go to the meeting, he says, "No, I need $4,000 up front just to get you there." And she says she paid it. So I don't agree that they were behind on payments. I agree that they should probably shot themselves in the foot and should have kept receipts. But that's not the record. The court did a marvelous job in trying to figure it out, and we got punished with about $9,000 and 9% interest because we didn't keep receipts. But that's the price you paid. It was clearly an effort to defraud these people, although fraud wasn't in the complaint. And he got hoisted on his own petard so far. And with that, I'll sit down unless there are questions.
I hear none.
Thank you, Judge.
Hear from the appellate in rebuttal.
Your Honor, my friend Mr. Alexander just told you that he didn't agree that there was a breach, and I would just reiterate that even under the favorable ruling, the favorable findings of fact that this court found on behalf of Ms. Moreno is still objectively, inarguably in breach of the contract based off of the findings of fact and the schedule of payments that the court found Ms. Moreno made. There was a prior irrelevant agreement for Mr. Mateo Lux and his family to live in the property. The relationship between these parties began in 2009. The only contract at issue here is the one that began on May 31st, 2011, not a prior agreement to live at the property and in exchange for work and repairs. Mr. Alexander said that he didn't think that the repudiation was clear and unambiguous. I'd point the court to the record. Again, this is Exhibit 7, the letter from June 20th, 2013, the letter from Mr. Jazzabi to Kenia Moreno. Despite many opportunities I've given you to catch up to terms of our contract in regard to the 5062 Mountain View Road property, you have failed to follow and even fallen further behind. Therefore, I consider the contract void. It doesn't get any more clear and unambiguous than that.
Well, except that you've got, so in the order, the court found or held that the lessees were entitled to specific formats, which indicates to me that the court found that the lease was not effectively terminated.
Right. And I think that's true, or at least ruled that to Mr. Alexander's point, that the court found that the option existed after the termination of the contract.
And so after that letter, lessor continued to accept payments on the lease.
He continued to accept payments for rent, Your Honor.
And did he say this was with reservation of all rights, or did he just receive the payments?
He would have just received the payments, Your Honor. Although even to that end, even you look at payments past this letter, they still don't add up to the $500 a month that it would have taken. But they would also be consistent with the course of dealing with these parties, because again, this family, the Moreno family, between her and her husband, has had control of this property since 2009. So there was already rent and occupation there before this took place. Then the contract at issue occurred. So then the fact that they stayed after the contract was terminated is not necessarily inconsistent with how they'd already acted when there was no contract prior under different terms. As far as the special stipulations, I want to touch on that. This is a pretty standard real estate contract, with the exception of the special stipulation. This is a standard contract of adhesion, commercially drafted contract. We would agree that anything in that special stipulations that is affirmatively stated would trump anything else in the contract. The argument that something in the negative not being there to your Honor's point about paragraph 15 would then trump paragraph 15. We would definitely disagree with that. We would agree with the court that, you know, paragraph 15 without being abated in the stipulations paragraph would still obviously apply.
Well, what's the exact language in the option note? Notwithstanding.
I'll go through it here, but it's a special stipulations paragraph. It says the following special stipulations, if conflicting with any preceding paragraph, shall control. So that goes to my point. Basically, anything in here that conflicts with something else, yes, this paragraph will control. But this paragraph obviously can't amend the entirety of the rest of the contract, or the entire contract would just be that paragraph. They would render the entire rest of the contract completely moot, because you would say if something's not in there, then, well, this doesn't say you can't do that. So that would be our stance on that. Essentially, it would need to be affirmatively in here in order to amend something else in the contract, which is consistent with the language, the following stipulations, if conflicting with any preceding paragraph, shall control. And Mr. Alexander talks about, hey, it's kind of generous and broad. It talks about what they might even be able to do if no financing was secured. We'll talk about what it says here. It says, if tenant cannot secure financing or pay off the balance at the end of this lease term, landlord will assume the property without any obligation to the tenant. That's not this gigantic, generous option that has been represented to you. And that is my time. Thank you.
Thank you. Of course, thanks to counsel for both sides. Again, we appreciate your briefs and your oral argument this morning. Call the next case, please.